Ladies and gentlemen, hello. My name is Nigel Smith and I am your moderator for this sixth and final webinar brought to you by the Council of Europe entitled Data Protection Views from Strasbourg in Visio. My colleagues Bohumila, Sophie and Anne are standing by to take your questions because we have a very strong lineup of experts. There will be a Q&A session at the end of the presentations, so please use the Q&A tool within BlueJeans to send us your questions. I can ask them on your behalf, or you might be able to put them to the expert yourself. Now, let's start with this conversation on the issues surrounding data protection in political campaigns. Colin Bennett is our first speaker. Welcome, Colin. You have 10 minutes, please.
Thank you very much. Let me share my screen. Are you seeing my slides okay?
We're not seeing your screen for the moment. There may well be a slight delay.
No?
Nothing's coming through for the moment. What we can do, Colin, is we can share your slides.
Let me try this.
Yeah, that works.
Good. Okay.
Thank you.
Good. Okay. Good morning, everybody. Bonjour tout le monde. It is 7 a.m. here, quite early, but I've had my coffee, so hopefully I'm alert. I was very grateful for the Council of Europe in asking me to write this paper on personal data processing in political campaigns. And that's available to you, and thinking about the application of the modernized Convention 108 to political campaigns. I wanted to start by just saying something about what we mean by this word democracy. I'm a political scientist, a political theorist, and I've written quite a lot about the relationship between privacy and democracy. And suffice it to say that privacy and data protection plays a whole range of different roles within different forms of liberal, participatory, deliberative democracy. And there's a very, very rich literature on that. We know that privacy is important for democracy, but until recently, until the Cambridge Analytica scandal hit the front pages, we've known very little about how privacy has been compromised by democracy, by the agents that seek to mobilize, engage us, encourage us to vote or not to vote. And my work over the last 5 or 6 years has been focused on those issues. There's a lot of trends, and I can't possibly summarize them here, but I do want to commend to you a wonderful report by the Tactical Tech Collective from Berlin, which has tried to identify the various trends around the world and the ways in which elections have become data-driven. The entry of commercial behavioral marketing techniques into political campaigning has produced widespread voter surveillance, as I call it, by a political influence industry where personal data is used as an asset, as intelligence, and as influence, particularly through this process of micro-targeting. And we've had a very rich debate about what these practices mean for various political issues. And there's been quite a lot of literature now on divisiveness and the extent to which it produces filter bubbles. There is concern about a marketplace of ideas when views are communicated in the depths of a social media platform and are not able to be countered by opponents. There's questions about whether data-driven elections actually have an effect on political participation, both positive and negative. It has effects on traditional forms of campaigning for volunteers. It affects our governance, and it affects the nature of the party system and electoral competition. Now, all of these issues are are being debated at the moment, and their effects are going to vary from country to country. But we do know that at the center of this debate is privacy and data protection. And so familiar data protection questions on transparency, fair processing, consent, security, accountability are now at the center of this international debate about democracy. Data protection regulators, privacy advocates, and of course international organizations like the Council of Europe are now at the center of this global conversation. And we also see changes, I think, in the views of elected officials who now over the world realize that the illegal and the unethical processing of personal data within elections can hurt them at the ballot box. If their opponents are doing something that they're not doing, then they can lose elections. So I've argued in a report that was delivered to the International Privacy and Data Protection Commissioners last year that privacy and data protection have rarely in the past been big P political questions, and I think they are now. And that report is available on the ICO's website. Challenges, however, are extraordinary. We tend to talk about political campaigns, but what actually is a political campaign? When do they start and end? Campaigns have become more permanent. They don't just occur during an election campaign. We know it's a global phenomenon requiring a high degree of international humanization. We know that there's a large, opaque, and shifting ecosystem of global actors, data controllers, and processors within this political influence industry that has variable effects on different democratic countries. Also, and this is extremely important, the interests on the other side of this debate are very compelling. We're not talking about security. We're not talking about the profit motive on the other side of the debate. We're talking about democratic engagement and mobilization. So political parties and candidates and those who engage in data-driven elections make the point that their purpose of processing personal data is actually one of democracy. And so the balancing test, I think, is very different. It's going to be different in different countries, but it's very different. It's also very difficult to convince politicians to regulate themselves. If you enforce data protection regulations on political parties, you're essentially constraining their ability to process data on the electorate and potentially constraining their ability to communicate, to mobilize, and to win elections. Different regulatory authorities are in this space besides data protection agencies, particularly election regulators, which after all have the experience and the knowledge of the different election rules in the different countries. And furthermore, there are many legal, institutional, cultural factors that affect the processing of personal data in political campaigns. I won't go over this in any great detail, but we need to be aware that the legal issues here are complicated. There are constitutional provisions on freedom of communication and speech, statutory rules, telemarketing rules, anti-spam rules. But then there are also political institutional factors that affect how personal data is used in a political system, the nature of the party and the electoral system, whether there's mandatory or non-mandatory voting, whether there's primary elections, as there are increasingly in some European countries, including France, whether there are referenda. All of these political institutional factors affect the way that data, personal data, enters a political system. And then there's a broad set of cultural factors that also need to be taken into account. For example, the general acceptability of direct candidate-to-voter campaigning, whether or not candidates come to your door, whether or not they phone you up. In some countries, that is expected. It's acceptable. In other countries, it's seen as a threat. The legacies of authoritarian rule are also extremely important here. To what extent we trust political elites. So the body of the paper that I presented here looks at some key issues that are expressed in Convention 108 plus, and also, I have to say, the GDPR, and tries to isolate those issues that I think require particular attention. of course, all of the convention applies to political campaigns, political parties, to the data processors and data controllers that are involved in this space. But there are some that I think pose some particular issues. The notion of identifiability and re-identifiability. What, in fact, is the threshold definition of data? Political opinions are defined as a form of sensitive data in both Convention 108 and in the GDPR. But in my judgment, there's not been sufficient amount of attention to what we actually mean by that term. And certainly there's not been enough regulatory activity in what is meant by that term. And I argue in the paper that it can mean a number of different things. It can mean one's ideology, one's belief system, whether one's a liberal, a conservative, a communist. It can mean one's political or partisan affiliation. It can mean preferences or beliefs about policy, what one believes about the economy, about the environment, about identity rights, and so on. And also it's important to note that these instruments protect information that reveal political opinions. And we know full well that political opinions can be inferred from a whole range of issues and behaviors that may, on the face of it, have nothing to do with politics. What magazines we read, what newspapers we read, what cars we drive, where we live, and so on. So a lot of things can reveal political opinions. And I try in the paper to sort of think about what we mean by that term. The rules on consensual political communications. Now, Convention 108 nor the GDPR makes no real distinction between commercial communications and political communications. And the rules concerning what a commercial organization can say to you and how it can introduce itself by email, by phone, by other mechanisms are essentially the same. On the other hand, some societies and certainly some political parties would argue that political communications and phoning people up in order to encourage them to vote is in fact a different form of communication than trying to sell them something. And that too, I think, requires more attention. Questions of proportionality. What are the legitimate purposes of political campaigns? That is the threshold test. What is the legitimate purpose? That may sound like an easy thing to answer, but of course there are a lot of possible purposes, democratic purposes here, which need to be balanced against privacy and data protection. The processing of personal data that is made public, you got into this issue in the last discussion about facial recognition, and there's actually been some investigations on this question, the extent to which data can be scraped, for example, from Twitter in order to, or other social media sites in order to profile people's political opinions. Viewed as a transparency across campaigning contexts, we should be aware that candidates and political parties and others campaign for a whole variety of different means now. Transparency is absolutely critical in all of those means. But it means different rules when there's campaigning on the doorstep, over the phone, by email, by social media, by text, and so on. And there's some intricate questions about what should be said, when, by how, to whom, about the legitimate purposes of that political communication. And then finally, and perhaps most importantly, the rules about automated decision-making and voter profiling. That is the issue that has been brought to attention most, I think, notably by the Cambridge Analytica case, but I discuss in the paper the issues there. So I have to conclude, and my main conclusion here is I think there's a really, really important role for Convention 108 plus in getting some guidance and some recommendations. It is expressly framed in democratic terms, and democracy is a condition for accession. I think it's uniquely suited amongst the different international instruments that we have available to address the privacy implications of data-driven elections, and particularly of reconciling privacy with the promotion of democratic practices in different countries. We define sensitive forms of data, we define political opinions the sensitive forms of data because of historical concerns over voter suppression and discrimination. And I think the Council of Europe has a really distinguished track record of promoting democratic practices in established as well as newer democratic states. And it has an impressive record of analyzing technological challenges to privacy and framing recommendations, and a breadth of experience across related regulatory and policy sectors. I also think it's an accessible and potentially a global standard that can serve as a powerful guide to best practices for the variety of data controllers and data processors within these political campaigning networks, which vary considerably according to my research in different jurisdictions. So I leave it there. I hope the paper is interesting for you. I'd really welcome your feedback. But I think the bottom line is I think there's a huge potential for the Council of Europe to be further involved in this incredibly important issue, perhaps develop guidance and recommendations on data protection and political campaigning based on the modernized Convention 108. Thank you for your attention.
Thank you, Colin, for setting the tone of this conversation. It's clearly a very important election year this year, and you say that there is an important role for Convention 108. Perhaps the President of the Parliamentary Assembly, Rick DAEMS, who is our next speaker, can set out the interest of the Parliamentary Assembly in this area. Welcome, Mr. DAEMS. You have 10 minutes, please.
Thank you very much for having me. I hope you're seeing and hearing me well, because my screen is a little bit strange, but okay. Just give me a thumbs up and I'm sure that I'm on board. Okay?
That's fine, thank you.
Okay. First of all, I'm pretty much impressed by the paper from Professor Bennett. Thank you for sending it to us. I would love to discuss with you on a number of these issues, not me personally, but I suppose a number of people in the Council of Europe, specifically in the Parliamentary Assembly, because we need to be elected. And that's what it's all about. You touched upon a number of issues. I would like to tackle it from a different side and then explain why I think that the Parliamentary Assembly is extremely interested in your views and having it within the context of Treaty 108+. What is politics about? What is campaigning about? Basically, it is about vote for me. It is as simple as that. Please vote for me. If there's no obligatory voting system, which we have in Belgium, please go to the booth and vote for me. What we have seen with the digitalization of campaigns is that it is no longer about vote for me, but it is also about do not vote for him or her, right? So you got the campaigning, which is about project, about what we want to do, what we propose to the population, to the citizen individually of project, what we want to put into practice, which is the promise of the politician to the electorate if you get his confidence. And one of the big things that I see happening is do not vote for him or her. Why am I saying this? Because I've got a little bit of experience with that, because in the last elections I had a vast campaign against me. I was used to having a lot of votes in my circumscription, and this campaign, when it was launched, it had as an effect that my personal votes were at least cut in half. I'm not saying this is the reason for, but this is the first time that I experienced it. So the point I want to make is it's all about vote for me, but then when you talk about elections, they should be free and fair. And so that is the angle from the Parliamentary Assembly that we want to take, because when we go to observe elections, for example, when we go to observe the campaign during the election, because we do observe elections before they take place and afterwards, the fact of free and fair is a definition that we should try to apply to this whole new field, which is the whole, what we call it virtual or how have you, the artificial intelligence-driven situation that we're all living in. So the free and fair issue is paramount when you talk about democracy, elections, and the issue of vote for me. And the vote for me issue also is no longer about this is a project, this is something I want to accomplish. Suddenly it becomes also in large part an issue of influencing people, persuading people of doing something. which has got nothing to do with a project, which has got nothing to do with where you want to lead the country to, and it's got everything to do with feelings, right? What are the two most powerful feelings that you have? It is hate and fear. And so what we see is an evolution, and this is something that also came out of Cambridge Analytics, by the way. I mean, if you address hate and fear, and by doing so you influence the behavior of the choice, you influence the choice, it is no longer a choice. It is basically a reaction to a feeling. And that to me is one of the biggest threats to democracy, because when you get into a field of hate and fear or other feelings, it is no longer about projects. It is no longer about what you want to do with the mandate that you have in order to do something for the country. And so when you reflect that back into political campaigning, if you reflect that back into the Treaty 108, it is obvious that political campaigning is something that should be under the umbrella of the Treaty 108 because of the effects that I am describing right now, because free and fair elections are basically hurt badly today by all of these techniques. Badly because they only play on feelings, they do not play on content. And as a matter of fact, the strange thing about it is that in the so-called real world, there's a number of things that we cannot do. But in the social media world, we can do it. I'll give you one example. If I, as a member of parliament, presenting myself again to the electorate, if I want to send a letter to potential voters, I cannot get a list. I am not permitted under GDPR to have an automated system using a list. But on the other hand, if I can get a grasp through other means to addresses, be it in the virtual world, I can do about everything I like. So the virtual world is not regulated, at least as my experience, as the real world is regulated. And so, in my mind, we should find a way to have the same kind of regulations that guarantee free and fair elections also in this other world that is reaching out to people. And so, again, the Treaty 108 Plus is the umbrella, and Professor Bennett said it, that we need in some way, and we've got very, very good people in the Council of Europe and outside of it, how to shift this under this umbrella and to guarantee exactly what I'm saying. We have, for example, in coming October, we've got 8 reports on artificial intelligence. Elements of that are in there, but they're not really aimed at political campaigning. So I would tend to say that maybe this is a separate field that we need to develop, again, in order to guarantee free and fair elections. And as far as I'm concerned, I mean, I'm quite willing to open up, all the resources that in the Parliamentary Assembly we have to address this issue. It won't be difficult. Why? Because all of us in here, we have been elected and we need to be re-elected. So you can bet on it that all of us are very interested to see, how can we have a fair shot at it, right? I'm saying it in a pretty simple way, but that's what it's all about. It is about vote for me. Voila. And so that has to be free, that has to be fair, there has to be a level playing field. Maybe one element that I would like to put into the discussion, and then I'll end it, because you've got so many interesting speakers, and I'm just talking about personal feelings also to a certain extent. Something that bothers me is, to what extent do we own our own lives in terms of data concerning us? I know that probably, if combined, I think about everything about my person is known, including my feelings, my choices, my fears, my resentments, and what have you. And so a question that I have is, to what extent do I own that? And to what extent do I need to be warned? Do I need to be notified that when I get a message, that it is using my personal profile? At least that I know that it is on the basis of my personal profile being in some way organized, I don't know how to say that the message is coming to me. At least that would level out a little bit of it. And that comes down to, okay, who is the owner of my data? I think personally that data concerning me should be my ownership. It should be my property, and it should not be used by anyone else except if I agree on it. And this is going against all these nitty-gritty little letters when you go onto a website and then they say to you, okay, could you just click a little bit here, then we can use your data? No one reads that. So we need to find a way in order to have a system that at least addresses that too, the ownership of your personal data and the way it is used and abused. Voilà, this is a couple of elements that I would like to put on the table in this discussion. It's not very technical. It is very practical, but at the end of the day, I can tell you that the Parliamentary Assembly is extremely interested into addressing this issue within the context of Treaty 108+. Thank you very much.
Thank you to the President of the Parliamentary Assembly for giving us the perspective of a politician. My takeaway was that Rick Daems was calling for regulations because of the fact that elections are so much driven by data. So let me now bring in Lucy PURDON, who is the Acting Policy Director from Privacy International. Lucy, welcome. You have 10 minutes, please.
Thank you, Nigel. Thank you very much for the invitation. I'm very happy to participate in this and champion Colin's great report. So PI is a registered charity based in London, and we work at the intersection of modern technologies and rights. In a nutshell, we challenge overreaching state and corporate surveillance so that people everywhere can have greater security and freedom through greater personal privacy. And we have a portfolio of work focusing on democracy. And in this, we look at data exploitation in the whole of the election cycle, from political campaigning to voter registration to voting itself. And I wanted to share some of our work with you today and some of the challenges that we're facing in kind of unpicking this issue of digital political campaigning. Next slide, please. So, as been said earlier, it's a really important election year, and elections globally are experiencing the impact of the coronavirus. Elections have been postponed in many countries. Where they've gone ahead, voters might see temperature checks at polling stations or be asked to vote by mail. And in this climate, we think it's likely that digital campaigning will only increase, maybe replacing rallies and meetings or other in-person campaigning that's probably going to be halted in order to prevent the spread of the coronavirus. So if this is to be the new normal, then there must be increased scrutiny of digital political campaigning. So at PI, we're really happy the committee might be looking at this and, for Colin's great report as well. Next slide, please. So PI has very serious concerns about data exploitation in political campaigning. We began investigating Cambridge Analytica back in 2016, and this was in the run-up to the 2017 presidential election in Kenya, and we were very concerned that the kind of intensive data collection and data analytics that a company like Cambridge Analytica did was very opaque and really quite risky, in a country like Kenya, not only because the country had no data protection law at the time, but also, elections are extremely tense there. They're run on ethnic lines, and there is a history of post-election violence. So we were really concerned about everything that was going on during that election. But it was very clear that Cambridge Analytica were the tip of the iceberg, and that there's this whole industry or ecosystem of companies often employed by political parties that are focused on getting your data. And Colin mentioned the great work of Tactical Tech in kind of, exposing this influence industry. So we were also asking questions like, who are these companies? What are they collecting? Where are they getting this data from? And then why are you seeing this advert and this message? Because since 2018 and the Cambridge Analytica scandal, there is still a focus largely on the area of what you're seeing, fake news, disinformation, and the content of messages. But at PI, we're interested in what is behind the curtain, if you like, not just what you are seeing, but why you are seeing it. What data is being collected and inferred about you that's resulted in you seeing this piece of content. It really is the other side of the coin. And the companies that make this their business model need to be exposed and scrutinised, as do the political parties buying the services. So this is why Colin's report and the work of the committee is so important. And I just found myself nodding along emphatically with Colin's report as I was reading it. Next slide, please. So I really love this line in Colin's report. Many of the current activities of political parties can barely be distinguished from current marketing organisations. This is so true. And later in the report, Colin identifies this campaigning ecosystem as political data brokers, digital advertising firms, data management and analytical companies, and political parties. Just take political out of there and you have the whole advertising ecosystem. Next slide, please. So I wanted to illustrate how difficult it is to investigate this industry with an example of PI's recent work. So last year in July, Facebook added a feature to allow users to view the advertisers who had uploaded your personal information to target you with adverts or exclude you from adverts that they were running. And looking at the list of advertisers who had uploaded our data, staff at PI found many brands that they'd never heard of or they'd interacted with, and this resulted in a year-long quest and hundreds of DSARs, data subject access requests, to try and find out where the brands were getting the data from. Now, the very short answer is third parties, but it's extremely complicated and we still don't have all the answers. So it's bad enough trying to get answers from commercial organisations, but what about trying to get the same information from political parties and ask why you've seen this message? It's also pretty bad. So PI was part of a group of organisations who wrote to all the political parties in the UK last year to ask who they were working with and where they got their data from in their to use in their campaigning. And shockingly, we received little or no response, which really is unacceptable, in a democracy. And one of the organisations who signed that letter, Open Rights Group, then went on to DSAR political parties and managed to obtain some information, but the data sources were listed as commercial suppliers, and more often than not, a credit reference agency was involved. So there really was very little transparency around, these lists of data or where they were getting the data from. And Colin also mentioned in his report that the ICO in the UK has warned political parties about this and about their digital campaigning methods. Next slide, please. So this week, PI published some recommendations that try to address some of the problems that we're talking about today, which might be useful. They focus on governments, legislators and regulators, political parties, and this ecosystem of companies that I've been talking about. And you can probably guess from what I've been saying so far that there's this overarching recommendation for all of these stakeholders. Next slide, please. Yeah, transparency. I know that sometimes this is an overused word, but more transparency is needed from all actors involved in digital political campaigns in order to shed much needed light on the data gathering practices, how the data is used, in particular for profiling, and then how such profiles are used to target messaging. And this transparency is vital to understand how political campaigns work now and how they may work in the future. Who campaigns work with, what data and tools they use, and how they use them. This transparency should in turn lead to appropriate limits being put in place and safeguards, and those that fail to comply being held accountable. Some other recommendations that we have are that comprehensive data protection laws must be implemented and enforced, and any loopholes that can be exploited by political campaigns must be closed. And we were really pleased to see this referenced in Colin's report as well. Electoral laws need to be updated for the digital age. They must reflect that digital political campaigning takes place outside of the strict electoral period. And Colin mentioned this earlier. And, we also would require detailed and timely reporting on campaign advertising and financing. And all of these legal frameworks must provide effective redress, both individual and collective, because we are missing that collective redress, particularly in the UK, and meaningful sanctions if they're violated. And then, of course, regulators, judicial and other supervisory and oversight bodies, in particular those responsible for data protection and electoral law, must have sufficient independence and adequate resources to enforce the law. And by that, I mean technical, human and financial resources. Next slide, please. So at PI, as you're probably guessing, we often struggle to get people sometimes to understand the importance of privacy in the area of political campaigning. Privacy and data protection is often skipped over in favour of a focus on content, as I mentioned earlier. But as Colin's report says, Questions about electoral manipulation, propaganda and misinformation are inseparable from issues of data protection. And we really support Colin's conclusion that the Council of Europe is perfectly suited to take this forward, and a push from the committee in this area in the form of substantive recommendations would be such a help to organisations like PI and all the other organisations who are working so hard to try and shed some light on this industry and, you know, bring data subjects their rights home. Because until, you know, we fully understand how this industry works, and force political parties to tell us who they're working with and where they're getting data from, we can't really have the adequate safeguards that we all need. And as digital campaigning increases, this issue is going to become all the more urgent. Thank you very much.
Thank you, Lucy. You say that a push from the Council of Europe is needed to bring the concerns that you've outlined to a wider public. Let's hear now from Nevena RUZIC, who is the Bureau member of the Committee of Convention 108. Nevena, you're coming in from Serbia. You're our last speaker today. You have 10 minutes, please.
Thank you, Nigel. Well, being a last speaker on Friday evening is a challenge in itself, so I'll try to be brief. Thank you very much for the opportunity to join this event. It is really a great privilege to be on this panel. I was eager listener throughout all three presentations previously. And with regard with the Convention 108+, I think Professor Bennett has already given us an overview how a convention applies to political campaigns, and I think we may conclude that it applies quite nicely. The report is amazing, so whoever didn't have a chance to read it, I think it's worth every minute and every sentence of it. Thank you very much on my behalf, at least. However, being an international document, of course, it cannot be applied to each and every specific case. As we all agree, I think that privacy is rather contextual, depending on how dear we take it, or how dear we take human dignity. Apart from the Cambridge Analytica and Brexit, there are, I would say, unfortunately, quite a number of examples of personal data being processed, conducted either on behalf of political parties for campaigns or even for elections, or by other actors as well. Back in 2013, the revelation of Snowden made people, at least in the United States, less willing to share their views that could be regarded as political or views or social views on any social or political matter. Just to give few national examples that are not technical. So we talk about personal data processing, but political parties are well equipped with the knowledge how to process data offline and also online. Last October, the Austrian Data Protection Authority fined with 18 million euros their post office for processing and making profiles of more than 3 million Austrian citizens, selling it to third parties. The processing is being linked to their political views based on subscription of the people. Just quite recently in Serbia, we had elections, and those were elections on local and national level. Well, it goes without saying that organizing elections in itself was quite a challenge, because pandemic is still on, and we have quite a number of cases. But nonetheless, the ruling party just before election used the contact address of each and every person receiving pension, and that goes regardless whether this is because due to age or disability or even family pension. So that means that even minors were getting that letter. And the question is, how did they at all get the whole database that appeared to be up to date to have each and every citizen receiving election in their own databases? But having said this, unless we are too deep involved in data processing and political campaigns, many of these cases remain under our radar. This is actually the concern, that we might hear of cases that are big enough because of the size of the country or because of the companies involved or the country itself. But it happens in each and every country, as Mr. DAEMS was explaining also in his own individual case. So the idea for my contribution today is to put a light on the work of the Consultative Committee to the Convention 108 and to explain how well it is placed to tackle these challenges. With a call to use this position that we already mentioned, both Colin and all three actually panelists on this panel said that the Convention 108 is a good standard or forum for that. So this is for mainly actually two principal reasons. So being open to non-Council of Europe member states, this convention, that's the committee, is fortunate to be able to avoid, I would say, somewhat Eurocentric view on privacy, because we tend to treat to some extent the privacy as a European baby with all concepts that belong to it. And that being said, it's also open for observers. It's not only that the member states that are not member states to the convention, but not member states to the Council of Europe that are contributing to this broad concept of privacy and why this is a universal value. We are also open to observers that have contributed to the work of the Consultative Committee throughout these years. At the same time, I would say that the convention is just one of the human rights instruments of the Council of Europe. And that being said, is that being adopted under the auspice of the Council of Europe, we always need to take into account what other committees or other bodies are doing. And just to illustrate with an example that is convenient for this particular panel is that last year, Venice Commission adopted a joint report with the Directorate for Human Rights and also for Information Society that dealt with technologies and elections. And in their in the conclusion of this joint report, privacy and data protection is seen as one of the core issues that needed to be addressed, while Convention 108 as a gold global standard. And I think we could work on that and having Consultative Committee as a forum, but also the Council of Europe Convention 108 as a gold standard for applicable not only to European states but also to other countries. So in this short time, I hope I managed to just to illustrate what how actually we know how well Convention 108 Plus is, but how also Consultative Committee, or soon to be the Convention Committee, is well placed to discuss, and also for a standard setting body. And at the end, I also have to say that the greatest effort is actually not given by the Consultative Committee itself, or the members of the Consultative Committee individually or jointly, but the Council of Europe staff. And so I really think it's important to mention all the people working at the Council of Europe that put us together and force us and push us and boost our energy as well to work on this issue, to take it as dear as they are. So without Sophie and the team, Peter and Bohumila and Anne and you, Nigel, for this, even this event would not be envisaged or organized or this well planned. So I think we owe gratefulness for their work as well. So at the end, it all comes up with people. We take privacy important because for us privacy is important. Thus, advocating for it, we make a change. So I see Patrick online, so I will leave now and give the floor to him. Thank you very much.
Thank you, Nevena, and thank you for your kind words. Let me go back now to the President of the Parliamentary Assembly, Rick DAEMS. Are you still with us?
Of course I am still with you.
I'm just going through some of the points you make in your presentation. You talked about your own situation in Belgium. You said that free and fair elections are hurt badly because of elections which are driven more and more by data. Let me put this point to you. How responsive is the political class to the concerns raised by data mining for election campaigns when it stands to benefit so much from the process?
Well, the point is that not everyone benefits equally from the process, right? So it also depends on the fact whether you have the financial means in order to do so or not. And so when I mentioned from the very start that the concern in the Parliamentary Assembly or in the Council of Europe as a whole is about free and fair elections. So I'm not out of this, but I'm trying to translate this concept of free and fair into the field of this digital world. And as I gave you a few examples, the worlds are very different. I mean, the simple example I gave you, I cannot use a list to send a letter to someone because this is privacy. But I can go today to any company if I got the money, and it isn't necessarily very expensive, and there I can do with the same list whatever I like, as long as I stay within the context under the umbrella of this digital thing. So there, basically, already it is not correct. I mean, this is like different rules. That's not a level playing field. Secondly, free and fair. Now I'm getting into a field which is rather psychological. How free is a choice of a person if this person is influenced in a, let's call it, unacceptable way? Okay, now we get into the field what is acceptable and what is not acceptable. But how free is this choice? In my view today, a lot of the choices being made are not free because they're based on basic feelings that are triggered through this tool. As I said, hate and fear are the strongest feelings that a person can have. Let's go into what extremism is doing. They target exactly that. They just target that. And if they have access to private personal data that know of which you are afraid, now suddenly your choice is no longer free because it is determined by a feeling being triggered by a tool. Let me give you a maybe a banal example. If I am very afraid of spiders, right? If someone could find that on the internet that I'm very afraid of spiders, and I get a targeted message from I don't know who saying, I will arrange the fact there will be no longer spiders in Belgium, well, maybe that would then, make me make a choice. Is that what we want? Is this like a free type of election? Then comes the fair aspect on the other side. When is it still fair? And within the scope of the fairness sits, amongst other elements, and it has been mentioned by all three, by Mr. Bennett and Madam PURDON, is like, okay, how fair is an election if I cannot participate in the same way than other ones can? If you look at the propaganda means of the 30s of the last century, they were as powerful then, because that was the new technology, as the means of today are now. Okay, if you make that kind of a comparison, it becomes extremely scary. And it is used by extremism because it is targeting feelings and it is not targeting content. Very difficult debate. But again, so I believe that the element of privacy, because this is the angle that we take, basically the ownership of something about you, knowing something about you that allows then, be it an algorithm or what have you, to trigger you into something, right? This is the scope of free and fair elections. This is the scope of level playing field. And does it need to be regulated? Unfortunately, to all my three colleague speakers, I can tell you one thing, forget it. We won't regulate ourselves, We won't, because we think that we will always be a step ahead of the other one. Okay, we may trail, but I see now it's like let's say it is like a speeding game of who gets the better algorithm now. If we can we can win the election. It is no longer about trying to have a policy to create jobs. It is no longer trying to have a majority, to have a policy in terms of gender equality. It's not about that anymore. Not at all. At least not in that field. And then comes the last remark. How large is the field of votes that are determined in the digital world And how large is the field of votes being determined in the non-digital world? I don't know. But if it would be like 2080, come on, is this a free and fair election? No, obviously not. So I am very concerned about it. And as I told in my, let's say, improvised presentation, because I didn't prepare anything because I wanted to speak from my heart, but I can tell you, if you are targeted by a hate speech, fake news, lie campaign, because in my case, you made a little bit too many votes as compared to other ones, and I cannot know from where it comes. Well, it has an effect, and it's got nothing to do with free and fair. So, yes, I think it is a field that we need to address. We need to address it on a global scale. I agree with Nevena. This is not a European thing, not at all. This is a global thing. This is about the future of basically, it's about the future of freedom. Because if tomorrow, if I can get my hands on an algorithm and I can use it the way I want it, and if this thing works well, bye-bye democracy, right? It's as simple as that.
I've got a follow-up question for the Parliamentary Assembly President, and then I want to bring in our other speakers. So, Mr. DAEMS, we've got a question here from Ian Brown. He puts 2 points. He says, can the Parliamentary Assembly pass a resolution supporting the committee in producing further advice on this important topic? I don't know if you want to make policy on the hoof on that one, but he also adds, can the Council of Europe cooperate with other intergovernmental organisations working on this subject, such as the Commonwealth, La Francophonie, the OAS and the OSCE? Where are we on this, and what can the Parliamentary Assembly do to bring the concerns that have been raised in this webinar to a wider political, to the attention of more politicians?
Okay, the second element, as where we are in terms of international cooperation, and Nevena will be able to answer that question. The point about are we willing to do so? Obviously, because any experience that we can share and any synergy that we can create in order to dig deeper into the issue, obviously we will welcome that. That goes beyond saying. Now, how does it work? Well, basically, you've got in the Council of Europe some departments, directors. I'm not so good at that, but still, I mean, we've got people, experts on the issue working on it, right? How does it work from our side, from the Parliamentary Assembly? We make reports, not really resolution. Okay, you've got resolution, but the only thing that matters is that we can get up to the level of what's called a recommendation. We need a 2/3 majority, whereby we ask to the Committee of Ministers, now these are the governments, range, and we say, listen, this is what we recommend to be, for example, in a regulatory body or in a type of regulation. And then the Committee of Ministers basically addresses this to a working group of the 47, and they start working on that. So that is how it works. If the question is, can we pass a resolution or a recommendation? Of course. I mean, this is something which is very sensitive to all of us, and we all want to have a fair shot at correct elections, obviously. So yes, we can do that. Yes, we will do that. And this is the way that we can basically trigger for it, to push rather the Committee of Ministers to work on it. Having said this, it's a little bit strange because now the members of Parliament need to ask to the governments who only represent the majorities in their countries to do something. Okay, I just needed to say that because this is something that's a bit strange in the way we work. Okay, I'll probably get a slap in the face by the Committee of Ministers having said that, but okay, that's politics. But yes, we will, absolutely. And yes, we can. Why don't we say that one again?
Thank you, President DAEMS. Let me bring in Lucy now. Lucy, you've got a question from someone who doesn't leave their name, but I think it's an important question. To what extent does the domestic micro-targeting ecosystem, how is that a priority target for hostile governments? Do you follow the thread of the question?
Yeah. Domestic micro-targeting ecosystem. Okay. Yeah, I mean, in terms of domestic micro-targeting, I mean, it depends which companies are being employed. I mean, it could be a European company employed in another country. Is it a target for hostile governments? I mean, we're still trying to, shed some light on how this industry works and then how it works in different countries. So, I mean, the best example we have is Cambridge Analytica, of how, they were in Kenya, they were in Ghana, they were in South America, their sales pitch was whatever the leaders wanted to hear, and they did all sorts of things that they were being asked to do. And, and in Cambridge Analytica's case, they worked in countries that had very little laws, so they could basically gather what they wanted and use the data for whatever they liked. I mean, hostile governments, hostile to who? It's a really good question. I like it a lot. And, it is the kind of question that we are trying to answer by trying to shed some light on how this industry works. I think also it's worth mentioning, we've been talking about this kind of the data brokers and, all this other kind of ecosystem. There is a focus on the platforms, rightly, who, do not apply their transparency consistently. We've been saying that this is not just a European problem, it's a global problem. Theoretically, you should be able to see who has paid for an advert and some of the information about where they got your data from, but this is not applied consistently across the world. I see, a colleague from Argentina there look at, with their report about, data processing and campaigning as well. So we're also trying to put pressure on the platforms to apply these policies that they're putting in consistently so that we can get more information about the data. So it's, we're just trying to shed light on each part of this ecosystem in order to be able to answer that brilliant question.
Thanks, Lucy. That sets up the next question to Colin rather nicely. Colin, Bethany asks, how can we get more information about where political parties get their data and how they use it? Bethany adds, it seems that data often comes from third parties. I think Lucy's made that point in her presentation and her interventions. So the data comes from third parties who gather the data, process it and subject it to analysis. Do political parties oversee this? And then she says the DSARS do not seem to provide enough transparency on this. How would you respond to the points made by Bethany? Colin, please.
Yeah, thank you. I'll respond to that, and if I may just add a couple of comments to the excellent discussion we've had. Clearly, we need more transparency. In order to get more transparency, I think we need more investigations by authorities that have the authority and the power to get the information. So I would argue that the data protection authorities need to be investigating these issues in their respective societies. At the moment, we have excellent reports from France by the CNIL and in the UK and a few others. But I think my own research has suggested that a lot of these issues that we're talking about, particularly in relation to free and fair elections, have been around for a very, very long time. And the intrusiveness of political campaigns, yes, it's been accelerated and exaggerated by Cambridge Analytica and the social media world, but the questions about what we mean by free and fair elections and what we mean by legitimate and intrusive campaigning are as old as democracy itself. And I think that in the history of data protection law, there just hasn't been enough attention to this issue by our privacy commissioner. So that would be my initial response to this. So yeah, more investigation. The more of that we have, I think the more light is shed, not only for the general public, but also for the politicians themselves. To Mr. Dam's point, one thing I've noticed in talking to elected politicians about this is that often they're extremely surprised, not only about what their opponents are doing, but also what their own political parties are doing. Wow, I didn't know that my campaign was actually doing that. What do I think about that? And I take the point that it's difficult to get politicians to regulate themselves in all of this. But on the other hand, there is also, I think, a deep concern for a level playing field, because the winner of one election is going to be the loser in the next election, right? And so we need to have a sort of a long-term view of this. Just one second point on the question about the free and fair election standard. I fully take your point that this whole area has to be linked up to those principles which are in all of our international instruments. And I'll do a better job of that when I revise the paper, I think. But I just would say that I think what we mean by fair and fair elections and the standards that we applied is now very different from what it was 30 years ago. And I think it's possible to conceive of a situation where you have free and fair elections, competitive political parties, freedom of communication, as we, I have to say, do in a country like Canada, and you can still have campaigning which is highly, highly intrusive. So yes, it's about propaganda and it's about feelings and it's about manipulation, and those issues have been highlighted by the Cambridge Analytica scandal. But I think there's a wider conversation here about how much do political parties and candidates actually need to know about an individual voter or a group of voters in order to campaign. I raised those issues in the other report I did for the DPAs. And when you ask that question, you get some very, very different answers depending on what country you're talking about. In the United States, it's virtually everything. Anything goes because of historic campaigning practice. Elsewhere, it's very little. And that's where I think that our political culture and institutional culture is so important to keep in mind as a basis for the legal questions that have to be asked here. Sorry, I rambled a bit there, Nigel, but I wanted to get a couple of things off my chest.
No, not at all. That was an excellent final point. Can I just ask the speakers, can we go an extra 5 minutes? Because we've got two more questions which I think I'd like to put to Nevena. And also we want to bring in Patrick Pennings to close this webinar. Would that be okay for the speakers? Excellent. Excellent. Nevena, we've got a question from João Pedro and another one coming in from Senegal from Adama. João says, this is clearly a dangerous subject. What specific best practices do you recommend when it comes to how we should deal with the freedom of expression issues that have been raised? That's the first question. And then from Adama in Senegal, from the Data Protection Authority, the question is, could you recommend a guide or a document on best practices on personal data and political campaigning? Perhaps the others, once Nevena has given her answer, perhaps the others can come in if they have information that will be useful to the questions asked.
Okay. Well, when it comes to what is the interesting and dangerous subject, in a sense, it deals with freedom of expression in a very wide variety of situations. I don't know whether there are any best practices. I think freedom of expression as well as privacy is something that we take differently as society. So in many cases, we didn't even have the opinion poll on how dear we take privacy and freedom of expression in terms of elections. So I don't know whether we have idea what fair elections are, or what transparency and what public, as Colin was saying, what is data linked to political opinion. So it's very vague. We have quite a margin of appreciation of all the concepts, each and every concept and all of them in one bucket. So I don't know whether there are any best standards apart from those that are, for example, okay, I'm promoting Council of Europe, but apart from those that are written by international organizations, taking into account the necessity or importance of both rights or interests, and at the same time having a vision that it applies to any country, regardless how long tradition may be in preserving human rights. So I think it's quite a difficult answer to say this is the best standard. In particular, for example, this micro-targeting is actually putting an opinion poll of political parties to a different or next level. So we are not going to question the whole population and have an idea what is expected from us and what we should maybe emphasize in our campaign, but we do it individually because, and at the end, it is unfortunate that in political parties, in doing so, they're not even interested in that individual, actually. So we are interesting individuals for political parties when it comes to profiling, as long as we fit into a box. They actually, but is it Nevena or Lucy that is actually not important for political parties? That's also something that we haven't discussed, but it's also important that people are stopped being people. That we are just data sets that certain other data set applies to.
Thank you, Nevena. I'm going to go to Colin and Lucy to ask that they respond to the question from Senegal about a recommendation on a guide or document on best practices on personal data and political campaigning. And then for a final word, we'll go to the President of the Parliamentary Assembly. So, Colin, any advice for our friend from Senegal?
Well, it's difficult to find something as of now, but I just heads up that the ICO in the United Kingdom is currently developing a code of practice for political parties there. And I think that's going to be finalized relatively shortly. And what they're trying to do is to really understand some of the peculiar questions about privacy in campaigning in the UK context, which I think might serve as a guidance for other countries. I think just one final point I'd make is that political parties, I've noticed the world over, tend not to see data protection authorities as quotes unquote their regulator. And so they're sometimes very, very defensive at privacy experts coming in and telling them how they should be processing personal data. They see their regulator as the elections regulator, however that's termed in different countries, that's regulating their finance, their campaigning, and so on. And oftentimes they don't like to have another regulator coming into their space. So that leads me to the conclusion that any efforts at codes of practice in this area in different countries needs to happen by both privacy commissioners, data protection authorities, and the regulators. It also leads me to a final point, which is that a lot of this can be addressed, I think, with the appropriate regulation of campaign finance. The reason why this is done so much in the United States is that candidates and parties have enormous amounts of money. The reason why it's done less in other countries is because there is very, very strict campaign finance rules, which effectively not prevents, but constrains the ability of parties to buy lists, do the kind of things that we've seen elsewhere. So that also is part of the picture, but it also accentuates my point that the regulatory challenge here is one in which the privacy advocates and regulators work with election regulators in different societies. And I know those powers are very different in order to establish a common code of practice that all political parties for all forms of campaign, election and referenda can adhere to in a sort of quasi-voluntary manner. Thank you.
Thank you, Colin. Lucy?
Yes, just very quickly. The report I mentioned in my presentation that PI produced this week also has a set of recommendations and best practice for political parties, which might be useful, including on how to limit the data used from third parties. I didn't put the link on my presentation, but I'm happy to put that somewhere that people can see it, maybe in answer to the question.
Thank you, Lucy. We've just learned that the Argentina DPA has posted a link about the best practice guide that is now available from Argentina. So you should be able to find that within the Blue Jeans environment. Let me go finally to the President of the Parliamentary Assembly. You want to make a final comment?
I just want to make one short point because it came up, freedom of expression. I want to add to that freedom of choice, right? And I would really welcome if Mr. Bennett, Madam PURDON, Nevena, and other ones, as you said, Mr. Bennett, to have this free and fair concept to try to work on that one. If you talk about fair, it's about what? It's about level playing field. Do I have the same chances as anyone else? And it's also about in or out of bounds of what is acceptable, right? Racism, what have you. Let me go to the free aspect. Until now, we always look at the free aspect as, am I free to rally? Am I free to campaign? Am I free to convince people? What comes up in my mind is, at the end of the day, given these techniques, these algorithms, this micro management of personal feelings, to what extent is the choice that the person makes still free? Okay, so this is something that I would like to see addressed, if possible. It might be psychological, I don't know. But at the end of the day, my feeling is that a number of the voters are no longer free in their choice because of the abuse of their private data and hence being manipulated through that. And so the free choice aspect as a person is something that I would like to see developed, if possible, obviously, because to me that is essential. That is really essential. I have to be free to choose whoever I want, and this is no longer the case, unfortunately.
Thank you to the President of the Parliamentary Assembly for those final comments. Thank you to Nevena, to Lucy, to Colin, and to all the experts who've been part of this three-day series proposed by the Council of Europe. Let me go now to the head of the Department of the Information Society here at the Council of Europe, Patrick Pennings, for his final words.
Thank you. Thank you so much, Nigel. First of all, let me say a few words and thank the participants of the last panel, Colin, Lucy, Nevena, and also Rick DAEMS, who in fact has taken on a bet in a way in trying to speak from the heart and not from a prepared speech. And that is very uncommon for the President of the Assembly, for a President of the Assembly. So thank you so much for that, because it gives us a very clear insight. Now, my task is really to close the 3 days that we have spent together. And I must say I was really thrilled by all the topics of these past 3 days. I would maybe have one suggestion for us for the future, and not call it data protection views from Strasbourg, but really call it data protection views from the world. Because that is what we have been doing. We have heard people from all continents. We have heard people on various different topics: evaluation mechanisms, profiling, digital identity, facial recognition, educational settings, political campaigns and elections, and with a fantastic lineup of speakers. And that has been enormously thrilling. Nigel already nicely summed up after each of the sessions the takeaways of the inputs that we have received, of the 24 different experts that were either data protection commissioners, practitioners, researchers, academia, NGOs, and committed individuals. And that was very interesting to hear and listen to the debate, 1 hour each, but very intense, very concentrated, very crisp, as it said in the program. And I was really very interested to listen to all of you. Now, as Nevena RUZIC already said, Convention 108 Plus tries to give exactly what we were referring to. That is, first of all, a level playing field. A level playing field with a global convention. And that global convention gives us a common legal space. A common legal space, but not only that, I think it also gives us a community of knowledge. And those 3 days, these exchanges have exactly contributed to that. That is to create that community of knowledge and sharing that information. And I thank all of them, all of you that were instrumental in doing so. Of course, my own secretariat, Bohumila, Anne, Sophie, and Peter, but also Nigel Smith, who comes from our Directorate of Communications and who has volunteered with us to moderate so diligently these 3 days. So thank you to all of you. I think the information on the program. The summary of each session you will find online on the Council of Europe Data Protection site. And I wish you all an excellent digestion of the 3 days, but also an excellent weekend for the ones that are starting the weekend right now. So thank you very much, Nigel. Thank you all. And thanks to all the participants, over 100 participants for each of the sessions. So between 100 and 150 participants, and it was really worth the while. Thank you so much.